Everybody, welcome to our immigration podcast. We do this every week. It's all things immigration in the United States. We try to get you the info so you know what's going on. All right, guys, this week it's not too busy, but I do have a couple topics to cover for you. I've got the 01 STEM update. USCIS made some changes. I've got some small news for you on just DUIs and how they might lead to trouble. We do get calls on that. Also, we'll look at the ICE student visa portal, focus on one section there that could be really helpful if you're looking at a student visa or you're on a student visa. Finally, we'll talk about naturalization process and the selective service requirement, and we'll end it with some Q&As from you guys. We'll have the timestamps down below if you want to jump ahead. Of course, give us a thumbs up and a like already if you've made it this far. Okay, first and foremost, the 01 visa. 01 visa is for individuals of extraordinary ability in the arts, science, business, athletics, and education. And essentially, for an 01, it's an individual who has to qualify by showing certain factors. And different industries have different types of factors, but immigration has given us some general guidelines. They have recently updated the guidelines to note that if an individual is applying for an 01 and they're in the STEM professions, it will be helpful, or one of the points of qualification, if they're named on a competitive government grant for STEM research. So this competitive government grant for STEM research can be a positive factor to demonstrate that the individual is the top of their field. This evidence and this factor has recently been added to the policy manual, which is the manual internally used by immigration to evaluate and set up how cases are evaluated. All right, at this point, if you got a STEM case, it's a new factor, could be very helpful for you. We'll get you more information as it comes out. I get a lot of phone calls from individuals who have either a small infraction or a DUI or something in the United States, and the question really is about, hey, I've got a DUI, is this going to affect my non-immigrant visa? So I'm speaking specific about NIVs, and that's everything from student visas to the TN, to the H-1B, J visas, L visas, anything that's not a green card. What happens if you have a DUI? Well, a DUI is a state-by-state law, and every law is a little bit different. So example, in California, most DUIs in California, while they're a misdemeanor here, they're not considered a crime involving moral turpitude or a high-level crime for immigration purposes. I know for a fact that places like Florida or other states have different levels of DUI where the actual DUI can be a high-level crime or a crime involving moral turpitude for immigration purposes. But what you need to know is simply this. If you're on a non-immigrant visa or if you're on a student visa, any misdemeanor can be seen as a violation of your actual visa, because the terms of the visa are to come to the United States to live and either work or go to school, the terms of your visa, and abide by the rules and regulations of the United States. So even a DUI, which in some states can vary, right? It could be low level or it could be a high level crime up to a felony. Even a DUI can be seen as a violation of your non-immigrant visa. More specifically, if you have a DUI on your record, it is very likely that at a consular interview, that means you go to an interview back at home for a new visa, they're going to subject you to what's called a panel physician review. And the Department of State has this process already in place. People with DUIs have to go and see a doctor, and the doctor is going to question them about their DUI and their drinking habits to determine if there's a current harmful behavior associated with the mental disorder or a history of harmful behavior associated with the mental disorder that is judged likely to reoccur in the future. All right? That whole long sentence is literally what they're looking at. So the DUI itself has several problems. First of all, in the United States, if you get one or two, you may not be able to come back. Second of all, if you're doing a consular interview and you have one DUI, they're going to still check to see if you're fit to enter the United States and no longer have what they consider to be a mental behavior or mental or behavioral problem that is associated with alcohol. Get a lot of questions on that, so there you go. I hope that helps you out. All right, I want to focus a little bit on something that's a resource available to all you guys, and you should be looking at it. Now, this is for F1 students. If you're an F1 student, you need to follow the link we put down below for you on the ICE SEVIS Students website. It's a great website. It talks about a lot of different things. What I'm going to talk about today is something very, very specific. The number 5 on their list of issues on entering the United States. And this is, what should I do when I arrive? Now, I get this question a lot, and I get it as in chats, or I get it during my free sessions. Hey, I'm a student visa, what should I do when I arrive? The most important thing, and you can take a look here at the website, you need to prepare your documents and show up in advance with your documents ready. You should be ready to show your I-20, your visa, anything related to you entering the United States, your passport, and if possible, some other school-related documents. But what you should keep in mind is this is not always enough, or perhaps there's an error. There could be an error in the system, in the SEVIS system, and you're stuck with an officer asking you a lot of questions. This is sometimes called secondary inspection. When an officer at the booth cannot handle you, you move to secondary inspection. Secondary inspection can be a scary place. You might spend several hours there. But the key for someone on a student visa is that you want to be prepared as best you can to answer questions. And sometimes I would even recommend that you have the phone number or business card of the DSO handy so you can make a phone call if necessary to that officer to help you with any errors that might be in your paperwork. With that in mind, you should look at your travel times as well. If you're traveling late at night, you might not have a student officer available for you, the DSO available for you. I think traveling during the day is really important so that you can get that DSO on the phone if necessary. I think you should also keep in mind that even if you have a problem, even if things don't look so great, if you end up at secondary inspection, they have the authorization to let you in the United States by issuing a form called an I-515A. They're allowed to let you in, okay, with this form to go correct the problem on your paperwork. What you need to keep in mind is you should always try to have that corrected before you come, but don't give up hope. If you've got a problem like this, you're going to get through so long as your paperwork is 95% correct and there's some error that needs to be just changed. You can get through this I-515A. To wrap this up, generally speaking, if you go into an interview, either at the booth or at secondary inspection, eventually they give you an I-94 showing your student status and a DS, status of duration of status. All right? Check out this website. It's a great resource. It solves and answers tons of questions that I get all the time, and I wanted to bring it to your attention for you or your friends who may be student visas or applying for student visa now. Another question we get all the time is about naturalization. Naturalization is the process of going from a resident to citizenship. One of the questions that I've gotten recently a ton of, it's about registering for selective service. If you don't know what that means, it's very simple. Individuals who are males, ages between 18 and 26, in the United States are required to register for selective service, which is the draft process. This can be very tricky because individuals might not have been here during that age or that time period, or the question on the application gets confusing. People think I should have registered, did I do something wrong? Here's what you need to know. For men age 18 to 26, you're supposed to have registered with the selective service. If you did not register with the selective service, you might have a problem during naturalization. And what you want to show during your naturalization process is either you tried to or did not know of this requirement. On top of that, there is a website we're going to link down below with the selective service because there's so many requests to prove what is required or not. They actually have a form letter that they offer that you should print out to take to your interview. It's a great resource, and if you're having problems with this question specifically, check out the link we put down below for you on the selective service, and check out this whole document with the policy behind it. It's very informative and will help you get through this process on the naturalization application. Obviously, if you need help, we're here to help. You can always call us for an appointment or hire us to help you with it, but sometimes people want to do it yourself. This is a great help for all you DIY naturalization people. All right, folks, we wrap it up with Q&A from you guys. We get tons of questions. I'm just going to help you with a couple that we've got today. I've got a question about a prevailing wage determination. This client says, we got the prevailing wage determination. We're in the ad stage. Should I do a master's degree now? Now, this is a pretty interesting question. They're asking, should they get their case and move themselves up to an EB2 level? That's what a master's degree is, while EB3 is bachelor's and below. The problem here is you've already begun a perm case, and the prevailing wage determination actually is the one document that sets in stone the education, training, and requirements and qualifications for the job that you need throughout the perm process. So if you've already got a prevailing wage and you're doing your ads, you're pretty much locked in on a job that's already been defined, that has an education attached to it and a salary attached to it, and that is going to be the job for you. If you do a master's degree after that, you might need to revisit the perm process to do a new case that is based upon your master's degree and thereby in an EB2 category. So point here, PWD done, doing the ads, too late to change. You're going to have to go with what you've already got. All right. Got another question here. I've got a J2 visa with a C5 category EAD. It's not on the list, USCIS list for automatic extensions. What should I do? Well, we put that link out a while back because it is actually specific. Your code must be on that list with USCIS for you to actually get the automatic extension on the EAD. So the J2 with the C5, if it's not there, I didn't look. If it's not there, then yes, you do not qualify for any automatic extensions on EAD. Our last question today is about a kind of complicated question where the individual's asking, hey, I've worked with subcontractors, and they list many. Can you help with a work visa? So this question is relating the work with subcontractors to work on a new visa. And the bottom line is always going to be, is there a connection between a U.S. employer and you? That is it. So while you work with subcontractors, and a lot of subcontractors work with individuals overseas, you still need a job offer from any U.S. employer to do work in your field for me to help you or for any attorney to help you. So it's a job offer from any U.S. employer. If that job offer is with a subcontractor, that's not a problem. If that subcontractor is offering you work in the United States, you can't be working overseas for that subcontractor. The new policy on H-1Bs and subcontractors is it's kind of cleared the table a bit. You can actually use the actual contractor or the subcontractor, depending on what your contract says, to get that H-1B and get that job offer. So what I would suggest to you is simply this. If you have job offers and they offer work in the United States, talk to an immigration attorney. It's highly likely that there's a chance for you to work either an H-1B or a TN or maybe even an L-1 visa in the United States. It'll be detail specific, and that's the best I could do with the question you asked me. That's it for now. Thank you guys so much for tuning in and watching our broadcast. We do this all the time. We love giving free content. If you got a question, send it, drop it below. We'd love a like, subscribe, share our link with your friends because we do lots of free content and we're always giving away news, information, things you need to know. Stay safe. Bye.